For those tracking major shifts in consumer credit and securitization, this is big. The Supreme Court recently declined to review the Third Circuit's decision with respect to the CFPB versus the NCSLT case. That's the National Collegiate Student Loan Trust case. Now, just last week, the CFPB proposed a $2.25 million judgment against the trusts. What does this mean? Well, the ruling could shake the foundations of securitization by challenging the isolation of the trust's underlying assets. Furthermore, and somewhat paradoxically, it could harm consumers by making the cost of credit more expensive. Join my esteemed guests, Steve Macy and me, to unpack these developments and their implications for the industry in the latest episode of the Consumer Credit Matters podcast. Watch or listen now to stay informed. Don't miss it. Steve Macy, welcome back to the podcast.
Thank you. Will Black, it's good to see you again.
We're back to, well, I guess we're going to talk about the Third Circuit CFPB versus NCSLT, National Collegiate Student Loan Trust case again. We have some almost breaking news. I guess in December, almost a month ago now, the Supreme Court decided not to hear that Third Circuit decision. So now we have, a period as a punctuation mark on that decision, and here we are again to discuss anew the implications for the industry. So really happy to have you on. I should tell listeners that we are not going to rehash in the same level of detail the specifics of that court case. If you're interested in that, and I hope you are, I'll put in the show notes a link to that podcast, which Steve and I did, I don't know, almost not quite a year ago, but back when that was breaking news. So I would point to that as a really good kind of foundational starting point if you're interested in the topic. But what we're going to cover today are the implications for the securitization industry of that now final decision. And as we discussed a little bit in that initial podcast, there are some, I think, potentially serious implications for the securitization industry that we want to highlight here again. So maybe with that, Steve, you can quickly summarize the case where where that case kind of left off in terms of its rule of law now.
Well, the CFPB, which is Consumer Finance Protection Bureau, had sued some student loan trusts, 15 student loan trusts, alleging that that the servicing of the student loans was improper in various ways, and the student loan trust said, okay, we've got servicers, and you could sue them, but you can't sue us. And the CFPB said, yes, we can, because you are what's called a covered person under the statute, and we are allowed to sue covered people. And so the case essentially went to first the district court, and then secondly the Third Circuit Court of Appeals. There were some constitutional questions which were resolved, and but the biggest question had to do with this question of this issue of whether or not securitization trusts, which are brain dead legal entities with no employees, no operations or anything like that, whether they are covered persons under the Act. So the Third Circuit found that they are covered people, and therefore the CFPB has jurisdiction over them, and so the case could go forward. So then it was appealed to the Supreme Court, and the Supreme Court denied review. It's something called, it denied cert, which is when to get review, it's you file something called a writ of certiorari, and so the Supreme Court denied cert. Mm-hmm. And so the case stays as it is, and goes back to the Third Circuit.
So
So, I mean, I think that's not a surprise because although there were constitutional issues involved at the lower court, they were not especially controversial ones, really. And I think the Third Circuit's resolution of those issues was pretty plausible. The other thing was essentially a matter of statutory interpretation, and the court will get involved in that. It would much rather Congress clarified things,
mhm.
but really, it's only going to get involved if there is a conflict among the circuits. And here there was, as yet, no conflict. So it said, nah, not time for us to look at this case yet.
So a bit of a Hail Mary. And as you said, not a surprise that the Supreme Court it didn't want to take a closer look at this point in time. Could take a look if there's conflict among the circuits at a future date. So we're left with this basically decision that erodes, damages the essentially the bankruptcy remoteness, or I refer to it as a moat between um, litigants and the assets that support the securitizations, the securities that are backed by those assets and held
Mhm.
by the trust.
Right. Yes. Yes. It's a moat around the trust, which is accomplished by the trust having no employees, no operations, no nothing. It's a bare legal entity. If you think about it, suppose you have. I don't know. You've got an infant daughter, okay, and
Mm-hmm.
you set up a trust for her, okay, and you hire a trustee, I don't know, Goldman Sachs or somebody, to invest this money. Okay. Well, and this then comes to your daughter when she reaches maturity. Okay. Is that entity involved in the business of, say, brokering securities or something like that? It is a passive owner of whatever it is that Goldman Sachs buys for it, but it is not itself a legal entity that can be sued if Goldman Sachs does something wrong. It's not liable to be sued there. It's just a purely passive thing. I mean, it's a nominal entity. It is a legal person, but under in the barest sense of the word. So um, that is a moat, which everybody has always that creates a moat. Everybody has always thought that protected the assets. If there is wrongdoing, of course, the companies who are engaged to service or perform services as trustee or whatever it is, they are obviously going to be liable. They're operating companies. They should be sued, can be sued if they behave badly. Absolutely, no question about it. The only question is whether or not the trust itself is also liable, along with the servicer for the things that the servicer has done.
Right. And up until now, up until this decision, uh, that has not been it has not really been a risk. I mean, there you can find some isolated cases over decades of of law, I suppose, where this um, isolation has come into question, but very few and far between, and call it idiosyncratic circumstances. Now you have law, you have precedent, certainly in the Third Circuit, that allows for a path for litigants to pursue based on whatever it is, the malfeasance or the actions or inactions, I suppose, of third party servicers, contracted parties to a securitization. Again, that type of legal path had not been as well paved as it is today as a consequence of this decision.
Yeah, I mean, there. It's possible to have, as you say, idiosyncratic problems. Somebody sets up a trust and does it wrong, let's
Right.
say, right? Okay, but here that's not the case. To be a covered person under the CFPA, you must be engaged in the business of consumer finance. Okay, so that's just a general, intuitive idea. None of those are defined terms, and so it's not that anybody says, "Oh, well, these particular trusts did something individually wrong." It's that they were engaged in the business of consumer finance, and therefore they fell under the CFPB's jurisdiction. That is something which is potentially applicable to every consumer, every trust that holds consumer assets, and potentially even commercial ones, because again, nothing here turns on the distinction between retail and commercial, right? They're engaged in the business of particular business. It happens to be consumer finance, but it could as well be, commercial lending, say.
I like the analogy that you presented in our first discussion around engaged in. I thought it was a really good one. It stuck with me, and that is, if you or I hire, I don't remember if you used an electrician or a plumber, but hire someone to fix the plumbing in our house. Are we, by this logic, we would be deemed to be engaged in the profession of plumbing, for example,
Yeah,
or
right.
as an electrician, and that is not the logic path that has been used for now decades. When you use it for the trust, which, as you said, brain dead entity that does nothing, chooses nothing, but has been set up on day one with third parties. In this case, the servicer is front and center to the decision, but there are other third parties as well to make decisions and take actions on its behalf.
Right. Yeah. It's not clear to me, actually. Whether this was misspeaking, or whether the Third Circuit actually uh, hung much on this. But the Third Circuit was actually confused, and it said that the trusts have an obligation to service the loans, and so the servicers are just performing that obligation for them. The trusts do not have an obligation to service any loans. They are an economic owner of the loans. They don't have any obligation to service anything. If they don't service, the buyer, the borrower doesn't pay.
Right.
It, it, the loans need to be serviced, right?
Right.
And so on. And you hire the servicer as the agent, who's the party who's going to do that. But it's not the case that the trust has a separate, a big obligation to service, and so it gets somebody else, and then it gets somebody else to do it, and then it can't say, hey, he's the wrongdoer, not me. Where in that, if I had an obligation and somebody does it for me, I'm primarily responsible, right? There is some sense in which I'm liable for what that person does, right? But that's what it seems the Third Circuit was on about. But that's just a misunderstanding of what's actually going on there. So who
So
knows what that is? But yeah.
So that's helpful. Why don't we move to what the implications are, and maybe we'll divide it in this way: is that, first of all, what kind of how is this decision likely to manifest itself for, say, existing transactions? What are the circumstances under which this decision is likely to have real world implications? I'd like to cover that question, and then separately, what can the industry, I'll put it that way, do to mitigate this risk going forward? So going back to the first question, back to you, is what are the circumstances if you had to categorize them broadly, that would likely cause this risk to arise in a given trust?
Well, those, I think they're separate questions there. One is what happens when you're setting up a deal, and
Mm-hmm.
after that, how might the trust stub its toe going forward? The problem is that the that it is such an open-ended uh, collection of risks. That's like saying how what are the possible risks of being in, what are the possible risks of being engaged in consumer finance? I mean,
Right.
where you're engaged in all 50 states, you're engaged in consumer finance. What are the possible risks? Well, I mean, they're enormous. Who knows? And first of all, though, you've got to be registered in each of the states as a this or that or the other thing, right? Which requires you to register, which requires you to have compliance people and all that kind of stuff. Um, that's just some standard stuff. Then maybe you do something wrong in that state, and now you're subject to litigation in that state, and so on. You there's really no way of that a trust can protect itself uh, other than by being a fully licensed uh, participant in that industry in every state in the country. If you're holding all 50 state assets, right? Whether they're mortgages or in this case they were student loans, but they could
Mm-hmm.
be suppose they're credit card receivables. Are you a financial institution in every state? And I mean, the potential implications are just sort of ridiculously large, and it's the open-endedness of those things that is so unsettling. I mean, you would not. It's the sort of thing that you would expect to sort of seep into the industry slowly as
Slowly.
people say, "Aha, well, now these guys are engaged in a business, right? Well, okay, well, we better make them. We better set a licensing requirement for them in our state, and we better do this, we better do that." Um, I mean, as a matter of fact, there's a political question here about what's going to happen with the CFPB in the next 4 years under President Trump, and whether its attention will go one way or another, what it will say, and what positions it will take, and so on. But this. Decision is out there as an interpretation of the CFPA, and that's potentially something that private litigants or states themselves can rely on or use as uh, ammunition for the argument that they ought to be able to regulate the trust, tell it what to do, sue it if they think the servicer does something wrong, and so on, all of which completely uh, undermines the ability of a bondholder to just look to the assets to determine what it is that he or she has.
Mm-hmm.
You don't just look to the assets. Now you've got to think about the risks of an operating company behind it, which is just completely counter to the whole idea of structured finance.
Let me ask you this: is there a way, in terms of kind of prophylactics, is there a way lawyers can draft the document to address kind of the root cause or risk with respect to you were talking about earlier, the definition of covered person or engaged in, and or can they make the indemnification language stronger than?
Yeah, you can do certain things, and I'm sure people are doing them. For example, in the documents that set up the trust, there is boilerplate in these documents, and it used to say engage in owning the assets, providing for their servicing, and so on. So presumably now you're not going to use the word engage
Mhm.
because a court has gone bonkers and decided that your boilerplate puts it under a statute. So yeah, there are things like that you can do, but you've got to be very and you can tighten up the indemnities. Yeah, absolutely. But here's an interesting question: what do you get indemnified for?
Mm.
There was a recent case in actually, I guess also the CFPB against FIA, Pennsylvania Higher Education Assistance Agency, which services an awful lot of student loans. Um, and the trusts and FIA entered into a settlement with the CFPB. Um, well, actually, this was because of alleged wrongdoing by FIA, but they didn't admit any wrongdoing in the settlement, and there was no final finding that there had been wrongdoing. So, in fact, the indemnification language was not or would not have been triggered, would not be triggered by that. It would come straight out of it would come straight out of the cash flow from the assets without any right on the part of the note holders to get the money back.
Mm.
It would just be considered a cost of doing business. So insofar as insofar as there is a settlement that does not uh, in which people don't admit any wrongdoing and there's not a finding of wrongdoing, you got to ask yourself whether this your indemnification covers you. Does it protect you? No, it doesn't. So you're going to have to think about how to draft that sort of language to make sure that you are covered.
Right, and so that's a bigger question than this Third Circuit
Yeah.
decision, right? So that's a question more broadly about the worth or value of an indemnification, which is also as a I guess a worth mentioning is it is only as good as or as valuable as the pockets are deep of that party which is providing the indemnification to a large degree, I would imagine. So if you
Right,
have,
but it is
yeah,
not. It depends on. I mean, the trust is not going to have anything that it needs to be indemnified for, unless it is liable as as we've been talking about. Um,
well, I was thinking, okay, so maybe let me clarify my question a little bit more. I wasn't thinking in those terms, although that certainly could be the case, and I hear your point. I was thinking more in terms of like, if the servicers fall down and are sued and have deep pockets, they're
mhm.
going to reimburse for whatever damages and penalties and fines to the extent that they are found liable. And therefore, the search for other parties that have assets to mine in a litigation, i.e., the trust and the assets that they're sitting on top of, in a sense, would not be pursued because there's no reason to pursue them if you're getting reimbursed from the indemnification clause of the servicer. Is that too far fetched, or is that something that and the reason I mention that is because I'm thinking about the circumstances under which you would pursue remedies using this Third Circuit logic now. Um, you have to have a few bad things happen, and the very least, the first bad thing you have to have happen is that the securitization arrangement in some way fails, right? So you have investors who are losing money or potentially losing money. Uh, Likely that one of the operating parties has failed, and or the collateral itself is performing poorly. So you kind of have to have one or more of those events going wrong at the same time and in a catastrophic way for the Third Circuit decision to actually have, kind of uh, to rear its head in a legal in a
Why I don't
litigation.
know. I don't know why that is true. You could have a securitization that was perking along perfectly fine,
Mm-hmm.
but then there are allegations that the servicer is, let's say, doing something wrong,
Mm-hmm.
and now the servicer is sued and the trust is sued. Okay, well, does the trust have money to pay for lawyers? It's got to pay for. It's got to defend itself now. A whole lot of other things are going to be costly, and it may well be that people decide, oh, the heck with it, it is better to settle than not to settle. So now a chunk of money is going to come out of the trust. It was perking along perfectly fine, but a chunk of money coming out of the trust might mean that, say, the most subordinate class takes a loss now, right? Um, uh, so I don't think it's just a situation where you've got a really bad securitization in several ways. And as we said, since the implications are so potentially open ended, as they get more and more and more real, the ways in which a perfectly healthy securitization could be impacted get larger and larger.
You bring up a good point, and this has certainly happened in that servicers may by from the perspective of cash flow expectations is performing just fine, but the servicer is being challenged for whatever too aggressive collection activities as an easy one, kind of a headline issue, and instead of and they decide to settle. And you're saying, whereas before there was not a path to the trust assets directly, there is now under this new
Yes,
precedent.
right,
Okay.
exactly.
So,
Yeah.
and yeah, okay, that's a fair point. Yeah. So, and that actually just underscores the point that this could have broad ranging implications. So you don't need to wait for the confluence of bad things to happen in order for this to manifest itself. That's the point you're making, I think.
Yes, and there's an interesting sort of subtlety about securitizations themselves that comes up, which is that there isn't really any single party that's like in charge of everything. You know,
Mm-hmm.
so in the CFPB FIA case that I was talking about, the question was, what do we do during COVID about forbearances and so on, and people were arguing in the deal. Note holders said, do this. One servicer wanted to do something else, and so on. And as a result, the FIA took no action whatsoever, and they left people hanging, and this allegedly caused people harm and so on. But the coordination problems in a securitization can be very real, and they can sort of, as in the FIA case, sort of paralyze decision making. And then what was an ordinarily good securitization is now not servicing as it ought to, because people can't decide what it ought to do.
Mm.
The trustee is certainly not going to tell anybody what to do. Always wants to be instructed what to do. The servicer, if people start threatening the servicer with lawsuits, it's going to throw up its hands and say, I don't know what to do either. Please just tell me. And then if different people, different bondholders, the equity versus the note holders and so on, start fighting and so on, nothing happens, as happened in this FIA case over during COVID. So internal coordination is is also potentially a cause of these kinds of problems.
So the risks are higher. How to gauge just how much higher they are, we're not going to know. We don't know, and we won't know that for some time, I suppose. But I'm just thinking out loud here that if the risks are higher, and they're higher for investors, certainly, because this is not helpful to the credit of the underlying credit of the assets that support their bonds. It's riskier arguably for the trustee rather, in their role, as you just outlined. They may be called into action and asked to take on a more active role. That could be one of the outcomes. They're going to want to be compensated for that, I guess, in both cases, right? The investors in my example, and the trustee. Maybe the servicers also want to be compensated more for whatever bolstered policies and procedures they feel they need to take on to protect themselves from these types of lawsuits and so on. what I'm trying to paint a picture of here, if it's not too far a stretch, is that there's going to be extra risks and therefore extra costs to protect from those risks going forward as a consequence of this decision. It seems to me, just how much, I don't want to overstate that, but it just seems to me on balance, it's not a stretch to say that this has real world implications to the process of the efficiency of securitization. And somewhat paradoxically, that is making the cost of financing and therefore the cost of consumer credit in general more expensive, which is, of course, at least in part, one of the mandates of the CFPB.
Yes, and of course, the costs to the industry, as the costs go up, uh, implications get larger. What I mean is, initially, right now, it's probably more the case that you're if you're potentially buying if you're buying, say, a first loss piece, or anyway, a deeply subordinate class,
Mm-hmm.
you'd better worry about some of this stuff.
Mm-hmm.
If you're buying a senior class, not so much. um, given the way things are. And as implication if implications grow, then the then you got to start worrying further up the capital structure.
Right. Right. Okay. Well, I think we covered most of what I wanted to cover anyway. I want to make sure that we didn't leave anything important off that you wanted to discuss as a consequence of this, the latest news on the case from the Supreme Court. So anything else, Steve, to add to what we've discussed already?
No, I don't think so. I think we've I think we've thrown enough stuff up in the air. So who knows how it will all fall out.
Yep, and I guess listeners, we'll be back on. Steve, I hope you'll join me again to discuss any future developments on this, because we just might see them in 2025. As facts and circumstances dictate, and possibly wend their ways through various courts and whatnot.
Yeah. Well, thanks, Will. I'm always happy to get on and give you any rants that I have in the back of my head,
Thank you.
and just let me know.
Very educational. Thank you, Steve. Really appreciate it. Thanks.
For
Thanks
sure.
everyone. Thanks everyone for tuning in. See you soon.